Motion moved. I now call upon the members whose names have been received for participation in the discussion. Dr. Amar Patnaik, Honorable Dr. Amar Patnaik.
Thank you, sir. Sir, I would have been belonging to the legal fraternity. I would have been very happy had other legal luminaries from the vacant benches would have been present here to listen to this deliberation. So mediation as a form of dispute resolution has always been there. It was a part of the Code of Civil Procedure 1908, Arbitration and Conciliation Act 1996, Companies Act 2013, Commercial Courts Act 2015, Consumer Protection Act 2019, in the Hindu Marriage Act. So the concept of mediation was always there. But what is so significant about this bill, and I feel privileged to be speaking on this, is that there was no standalone mediation bill in this country, and this is the first such bill after independence which is being introduced in the House. So it is my privilege to be speaking on this bill, particularly belonging to the legal fraternity. So the point here is, in 1908, the Code of Civil Procedure was there. But why this culture of mediation was not there in our country? Why this was not happening, even if so many bills were there? And why the need for a separate bill? So there are 5 basic reasons for it. So the basic reasons were that the judges didn't always refer cases for mediation, even though they accepted that this culture is very necessary for removing pendency in our courts. In our courts, for example, sir, now approximately 5 crore cases are pending. So mediation, alternate dispute resolution mechanism, is an effective way. But the judges, for example, in Delhi High Court, only 2.6% of the total number of cases in the High Court were referred for mediation. The second point was there was a lack of clarity on enforceability, whether the mediated settlement would be enforceable in the court of law. The third point was there were some myths associated. The myths were, for example, that mediation is a lesser form of justice. Unless you go and get a judgment from the court, it will not be accepted as a great piece of judgment. The fourth point was that even the lawyers, they were not incentivized to get cases referred to mediation to settle the cases. Now, because of these factors, I think the current bill addresses many of these issues, and I feel this will be a standalone, significant legislation for the country, and this will go a long way in improving the ease of doing business in this country. It will also solve a number of problems of pendency in the lower courts, particularly for people who belong to the disadvantaged section, people who are poor, people who can't afford. So the unique thing about this bill, as the bill suggests, is to promote and facilitate mediation, particularly institutionalize the process of mediation. So institutional mediation, community mediation, online mediation, all these have been enabled in this particular piece of legislation. And therefore, it is a very significant piece of legislation. Now I'll come to some of the provisions of the bill, sir, point by point, and make suggestions to the Honorable Minister who is present here, in case we can actually incorporate some. Section 28(2) of the bill states that mediated settlement agreements shall be enforced in the same manner as if it were a judgment or a decree passed by the court. Now, this basically means that even if you win a case in India against an international, there is a person who is your litigant, you will not have the advantage of worldwide global enforceability. You have done so much, you might win the case, but for enforceability, you will not be able to take advantage of the Singapore Convention. So why to unnecessarily have this particular provision? Be in compliance with the Singapore Convention, in which case our people will tend to get the benefit. Those who win against an international opponent in our country, they will be able to enforce it globally. They will not be prevented by our own legislation from going to taking advantage of the Singapore Convention. Now I'll come to the second point relating to the definition itself. Now, on the definition of mediation, which is there in section 4, I see that, it is a very wide, expansive definition. I completely support. And there's a word there, conciliation. People believe conciliation is a separate process. But I think the bill has done right, the government has done right by including conciliation, because the Supreme Court has now held in the Efflon's judgment that both mediation and conciliation can be put on the same footing. So I think this is a good piece of definition that is there provided in the bill. The second point that I wanted to make is about, the confidentiality clause for online mediation. The confidentiality clause has been provided. It is at the heart of the entire mediation process, but for violation of confidentiality, the penalties and offences on either the mediators or anybody is not prescribed. I think this could be provided in the rules. There is no certainty, there is no provision for enforcing certain international mediated settlements. For example, if an Indian person is going through a process against an international opponent in a foreign soil, where does he get it? Because you are already precluding the possibility of global enforceability by having that provision in which the Singapore Convention advantage cannot be taken care of. There is a point I want to make relating to composite reference mediation. Sometimes out of a contract, several sub-agreements happen. Each one of them might get into a separate mediation process. If you allow each one of them to go through the entire process, then you will be unnecessarily wasting time. So a provision could probably be made in which the concept of composite reference mediation in the Mediation Rules 2021 could be brought in. The provision, in the bill, there is a provision which says that the Act will not apply to pending proceedings. When the pendency is already huge, and this particular Act brings in the element of enforceability of the mediated settlement, why not apply it to the previous cases? Because in such cases, there will be seriousness that the government would be showing. The another point is relating to community mediation. In community mediation, the option has been left to the SDM to decide. But I think in community mediation, just like our sarpanches used to do in Punch in the earlier times, I think it should be made mandatory for the SDM to involve the community leaders, in which case the mediation would be more successful. Mediation will be accepted by both the parties. It will be more having the more force of law, in the sense the local community people are also supporting it. So make it mandatory for the SDM. There is a provision which is relating to requiring central government approval before issuing regulations. Now, in the Bar Council of India regulation Act, and in the National Medical Commission, which was passed recently, there is no such requirement. In professional kind of jobs or professional services, I think this kind of reference back to the central government each time may delay the process. However, I commend the government for reducing it from 180 days, 6 months plus another 6 months, to only 6 months. I think this is very admirable. The last point which I wanted to make is something on which the standing committee has taken a view which is different from the original bill. The government has accepted the standing committee's view, but I would like to support the government's previous view, which was to make the pre-litigation mediation mandatory in phases. If you look at Justice Ramana's first speech in the Singapore-India Mediation Summit 2021, he says that mediation should be made mandatory as the first step for dispute resolution, and a law should be framed in this regard. The government in its wisdom had brought it. There was of course a question as to whether the right to judicial remedy, which is provided as a fundamental right, would be hindered because of this provision. I think a way around could have been found out, but unless that is done, people will not be serious about mediation culture in this country, and settlement of disputes may not happen to the desired extent, even though the law is very robust. Lastly, sir, the government is the main litigant in several cases. And I think instead of completely taking government, state, central, every agency of government out of this entire process, a a solution would have been found in which some amount of cases through the mediation process, which has enforceability, could have been provided in the Act. This was also a recommendation of the Standing Committee. I think you would probably like to reconsider it. Once again, I support the bill. As I said, this is the first standalone mediation bill in this country, and it's a significant piece of legislation. I completely support the bill. Thank you so much.
Wonderful.